The next panel is the second charter panel, and it will be, the panel will give papers on selected substantive issues, Paul Schabas, Laurie Sterling, and Professor Young. I'm going to introduce with pleasure the chair of the panel, Paul Schabas, and then Paul will take it from there. Paul is a partner at Blake Castles in Graydon, a former partner of mine. He's a leading constitutional litigator, highly experienced, a leading libel lawyer, highly experienced. He's litigated cases in New Brunswick, Manitoba, Ontario, the Federal Court, and the Supreme Court of Canada, national lawyer. He's written numerous articles on constitutional and criminal law topics, given numerous lectures of this sort. He is a former chair of the Constitutional and Civil Liberties section of the CBAO, and he will be, as I say, leading the panel, and he'll introduce the members.
Thanks, Neil, and good morning. Maybe I'll just take a moment and introduce my fellow panelists. To my far right is Laurie Sterling, counsel with the Ministry of the Attorney General in the Constitutional Law and Policy Branch. Laurie is a leading constitutional lawyer with the Ontario government. I have had the pleasure of having a number of cases with her, and I always know that if I ever had a chance to begin with when I serve a notice of constitutional question, my chances of success go down when Laurie is the one who phones me and says it's her case. She is a pleasure to have a case with. Laurie graduated from U of T Law School a year ahead of me in 1983. She has an LLM from Cambridge, where she received the Rodwell Prize for coming first in that program. And after a brief stint in labor law, she joined the Ministry of the Attorney General in, I think it was 1988, and has practiced there ever since. She's written widely and has appeared on a great many cases in the Supreme Court on leading constitutional cases, including one that I'm going to talk about at length in my paper, which I did not appear on. So she knows it better than me. The other panelist is Professor Alan Young, who is a professor at Osgoode Hall Law School, has an LLB from Osgoode and an LLM from Harvard. He clerked for Chief Justice Laskin, worked for the federal government, and as he was just telling me, practiced criminal law in the early days of the Charter when, as he put it, you could say just about anything in court, and he didn't go on and say, and you'd probably lose just about every time. But since 1986, he has been a professor at Osgoode, specializing in criminal and constitutional law. He, of course, as all academics do, has published widely. The publisher parish gets to everybody. But Alan continues to publish and is as well an active criminal defense lawyer, most recently acting for Stephen Williams, the author who is being prosecuted over his book about the Bernardo case. On to my paper. I'm conscious of the fact that the treasurer yesterday morning said these are supposed to be more academic. I look on my paper as a bit more one of advocacy rather than academia, which you're welcome to disagree with. I think, though, my paper is really drawn from my experience as an active media lawyer. I do a lot of media law, as Neil says, and that means that on a daily basis I am dealing with constitutional issues that affect the press, issues such as publication bans, access to court, access to records, access to the government, responding to subpoenas and search warrants on the press, dealing with freedom of information applications, and as well, in another context, dealing with libel law and advising the media both before and after things are published. And as I thought about what I should talk about in the paper, it struck me that this was an opportunity to discuss what I regard as an inconsistency in the Supreme Court of Canada's approach to freedom of the press under the Charter. And what I mean by that is that the Supreme Court has been very ready to embrace the Charter when talking about freedom of the press and open courts and scrutiny of government. And the Edmonton Journal case, the Dagenet case are the classic examples of that. And yet, when it comes to libel law, in the small number of cases that have come to them, they have been, in my opinion, very dismissive of the Charter and its impact. And that's seen particularly in the Hill and Scientology case, where the Supreme Court, almost without discussion, in my view, came to the conclusion that our common law principles of libel were really unaffected by Section 2B of the Charter. And let me take you through the argument. First, of course, freedom of the press is nothing new. It's been around for centuries. It was the foundation amendment, if you will, to the U.S. Bill of Rights. It's been talked about in English law for centuries, and indeed, the Supreme Court of Canada spoke very strongly about it as long ago as 1937 in the well-known Alberta Statutes case. This principle of freedom of the press and freedom of speech generally is based on our notion of participation in our democratic society and in government. But even prior to the Charter, even back in the 1950s in Switzman and Elbling, Justice Rand commented on the breadth of freedom of speech, didn't just limit it to political speech. Naturally, it was included in the Charter. As I said in the paper, it's almost unthinkable that you could have a Charter without freedom of speech and freedom of the press. And indeed, it has been interpreted very broadly. Virtually any activity other than violent activity, if it conveys some meaning, is expression. We'll find out, I guess, whether that includes bear hunts when Bob Charney's case is done. And really the analysis, if there's any kind of expression, the analysis shifts to Section 1, which I suppose confirms John Terry's thesis yesterday that virtually all Charter arguments take place under Section 1. And the courts have spoken, though, about just how important it is. Cases such as Edmonton Journal, which has now been adopted, Mr. Justice Corey's judgment has now been adopted by a unanimous court in CBC in New Brunswick, says it's difficult to imagine a more important right than Section 2B. It should only be restricted in the clearest of cases. And indeed, when one looks at the freedom of expression cases generally, one sees a very broad approach to that. Even Ernst Zundel was successful in having the section of the Criminal Code of willfully publishing false news struck down. And I found that case particularly interesting because there, Justice McLaughlin commented on the fact that even false statements can have value. There is value in protecting even the right to make false statements, even in that case when they may be done deliberately. She points out that exaggeration, satire can be very effective forms of communication in drawing attention to public issues. She also noted the concern about readily identifying what may or may not be false, and that prohibiting false statements in advance can have a chilling effect on speech. It's interesting to contrast that with the Keegstra case, an interesting contrast I'll come back to when I talk about the Hill case, that in Keegstra they upheld the willful promotion of hatred, a different concern, in my view. Now, let's jump to the press and how this affects the press. I cover three areas in my paper: open courts, news gathering, and defamation. The open courts principle, of course, has been around for a long time too. I still regularly rely on and use for my arguments the case of McIntyre, a case decided just prior to the Charter by Chief Justice Dixon, but it certainly reads like a Charter decision and has all of the great principles of openness and public scrutiny, and quoting Jeremy Bentham about the darkness of secrecy and how that's to be avoided. And we all, I think, would agree that open courts is a fundamental, important principle. Yet the reality is, until perhaps 6 or 7 years ago, the open courts principle was readily displaced, even following the Edmonton Journal case. We didn't question many statutory bans. most common law bans, such as wherever a defense counsel would say, well, there's a concern here that if this gets out into the press, it might jeopardize a fair trial down the road. The judges would readily say, well, we better put a publication ban on it, or we better exclude the public from the courtroom. And the most notorious example of that was, of course, the Karla Homolka guilty plea in 1993. Many of you will recall the frenzy of media lawyers, of which I was one, who drove down to St. Catharines day after day trying to get that open. And of course, Mr. Justice Kovacs excluded just about everybody from the courtroom. Of course, it all dribbled out over the next several weeks, or most of it dribbled out. But nevertheless, he applied the old view, the common law view, that when there is a risk of any kind to a fair trial interest, we exclude the public, or we impose a publication ban, one or the other. There he felt he had to go further and exclude everybody but the people that he called the accredited media, which I recall, to Stephen Williams' frustration, did not include him at the time, because he had introduced himself as an author and not a reporter. Then, though, along came Dagenet, the decision of the Supreme Court that arose from the Boys of St. Vincent docudrama. You'll recall that the CBC had prepared a docudrama dealing with Christian brothers and sexual abuse, and a number of Christian brothers were either on trial or facing imminent trial in Ontario at the time the shows were to be broadcast, and they successfully obtained an injunction preventing it from being broadcast because of their concern about fair trial rights. And indeed, it was upheld by the Court of Appeal. The Supreme Court, however, fundamentally changed the law, and I believe firmly that this makes it the most important freedom of the press case that's been decided to date, because it threw out the notion that, well, if there's a fair trial risk, that's it. We've got to protect fair trial. That trumps freedom of the press. It trumps the public's right to know, which is what we're ultimately talking about, and was made clear in Edmonton Journal. And what they did, and this is of course relevant for all charter jurisprudence, was the court said there is no hierarchy of rights. All rights in effect are equal, and what we have to do is engage in a balancing of rights. And when someone is trying to limit a right, such as the Crown or the accused, where they're seeking to limit publication or limit access to the courts, they have a heavy onus, they bear a heavy burden to justify that limitation. And the court goes into some detailed analysis about looking at alternatives, about ensuring that there really is evidence of a substantial risk, and of making the point that remote or speculative concerns, or saying it is so, isn't enough. The Dagenet approach, I argue, would lead to a different result today with respect to a case such as Karla Homolka, and indeed has led to different results in other cases where similar issues have been raised, where co-accused are pleading guilty and someone else is facing a charge later. It's also had a significant impact in other cases. I believe Chief Justice Lesage was conscious of it in letting more information than would ordinarily have come out be reported on during the preliminary motions in the Bernardo case. The Just Desserts case, which recently ended in Toronto, saw some extraordinary reporting permitted by the trial judge, Justice Trafford, where he permitted lengthy reporting of his decisions on voir dires, dealing with admissibility of evidence and dealing with abuse of process. Highly critical rulings criticizing the police, the Crown, the defense, the accused, opening himself up for a good deal of criticism as well. And I say that that is a most dramatic example of the effect of Dagenet. Permitting the reporting of pretrial motions, of voir dires, was unthinkable before Dagenet, and was virtually unthinkable before Just Desserts. Yet it is an approach that he takes directly from Dagenet, and the importance of opening the courts up to scrutiny. I'm going to skip over the news gathering. I talk about it briefly in my paper. In that area, I'm concerned that we may be going backwards. The courts seem to say the right things about news gathering. This is protection of sources, or the right of the press to be free from search warrants and subpoenas. But in reality, I'm not sure that the cases that they have decided give any real protection and in fact may take some protection away from the press. What I want to focus on more specifically is libel law. And as I said, I believe their charter has had virtually no impact, at least at the Supreme Court of Canada level. Fortunately, Hill is not a media case, and as I note, it may be explained and hopefully ultimately limited to its facts. The plaintiff was a well-known lawyer, well-known Crown attorney, now a judge, libeled by an unpopular organization. And one thing we learned from the case is that the Supreme Court of Canada seems to believe that lawyers, that most unpopular profession in society, ironically seem to have the most precious of reputations. In Hill, the Supreme Court was confronted with the charter argument that our common law of libel is out of step with the charter and that the court should adopt the approach of the Americans in the famous case of New York Times and Sullivan. Just briefly, our common law of libel is that libel is a strict liability tort. Once words appear to be defamatory on their face, in effect the onus shifts to the defendant, who must prove the truth of the words or must establish the defenses of fair comment or qualified privilege. And in 1964, the U.S. Supreme Court said that law inadequately protects freedom of speech. They said the press shouldn't be required to guarantee all statements if they are about public officials. It was subsequently extended to public figures generally, so long as the press did not act maliciously or with reckless disregard to the truth. And the court effectively reversed the onus and put the burden on the plaintiff to prove that the words were false or to prove with some convincing clarity that the defendants knew or were reckless as to the truth of the statements. The Supreme Court was asked to make the same finding and gave the argument, in my view, quite short shrift. And I quote from Justice Corey, where he says that he can see no reason for adopting New York Times and Sullivan, although he does say between private litigants. However, it's always going to be technically private litigants in a defamation case, whether they're a public official or not, and simply says, I simply cannot see that the law of defamation is unduly restrictive or inhibiting. Surely it is not requiring too much of individuals that they ascertain the truth of the allegations they publish. Those who publish statements should assume a reasonable level of responsibility. And he goes on, and this is in fact, I believe, more troubling, to say, certainly defamatory statements are very tenuously related to core values which underline Section 2B. They are inimical to the search for truth. False and injurious statements cannot enhance self-development, nor can it ever be said that they lead to healthy participation in the affairs of the community. And he goes on to quote the Gatley text on libel from 1953, saying it would tend to deter sensitive and honorable men from seeking public positions of trust and responsibility and leave them open to others who have no respect for their reputation. It's my view that that position is simply out of step with what the Supreme Court is otherwise saying about freedom of the press and freedom of expression. He doesn't balance or say there should be a balancing to engage in when you are limiting freedom of the press and freedom of expression. In effect, he is saying that reputation trumps freedom of expression. That is inconsistent with Dagenet, I say. And I say that his comment that defamatory statements are tenuously related is actually the same language he uses in Keekstra, where the court, or not he, but where the court upheld the offense of willfully promoting hatred. Now, of course, libel law doesn't require willfulness. It's a strict liability tort. You can have honestly believed in the truth of what you're saying. You can have taken many reasonable steps to check the accuracy and truth of what you're saying. But if at the end of the day you got it wrong, that's it. Too bad, no defense. And in my view, Justice Corey and the court really miss the boat here when they just conclude, well, it's a defamatory statement, therefore we shouldn't give it protection, or it's so tenuously related to Section 2B that we shouldn't give it protection. And it's fundamentally opposed to the approach they take in Dagenet, where they take an explicitly protected right, the right to a fair trial, clearly articulated in Section 11D of the Charter, and say even that has to be balanced against freedom of expression. I note in the paper that, in fact, the Supreme Court is not only, I believe, out of step with itself, but it's out of step with Australia, which does not have an entrenched Bill of Rights, and it's out of step even with the English law, both of which have recognized the importance of freedom of expression outside the context of a Charter of Rights, and have recognized the chilling effect that our common law of libel has. The Chief Justice of Australia said, "It seems to us that the law of libel is inconsistent with the requirements of the implied freedom of communication because it has a chilling effect. It inhibits discussion of political matters." Even the English House of Lords in the Derbyshire case noted that quite often the facts which would justify defamatory publication are known to be true, but admissible evidence capable of proving those facts is not available. And therefore, that doesn't necessarily mean that they should be subject to the strict liability rules of libel law. Hopefully the right case will come along soon to correct this, and I'm comforted at least a little bit by Justice Corey's aside that on the facts of this case, common law of libel does not violate the Charter, but nevertheless I'm concerned because in my view the court went much farther than it needed to in confirming our common law principles. I note that there has been some movement since Hill and Scientology. One case, bizarrely almost a pleadings case, Mr. Justice Sharp, when he was sitting in the divisional court, commented on charter values and said we've got to start changing the libel laws to accord with charter values, and said that the law with respect to pleading a libel case should change so that the defendant can plead their own meanings of words, their lesser truthful meanings that they want to prove, that a defendant shouldn't be restricted to the playing field defined by the plaintiff. In the area of qualified privilege, without changing the law, we have seen some courts recognize, apparently inconsistently with some old Supreme Court law, that that defense can apply to the media, where they can have a duty to report something to the public at large. There are some cases to the contrary recently too, but there is a recent Court of Appeal case and a couple of recent Superior Court decisions that are pointing that way, and I think are recognizing the important role of the press consistent with the Charter. I'll leave aside the Lucas case, which I talk about briefly in the paper, the criminal defamatory libel case, which I find astonishing, where the Supreme Court confirmed jail terms for 2 individuals for defamatory libel. I guess the concern about that, regrettably, is that it shows that Hill is not an anomaly. And I would conclude by referring to a very recent decision, again in England, in the House of Lords, a case of Reynolds and Times newspapers, where a former Prime Minister of Ireland sued the Times over allegations that he had misled the Irish Parliament. And although he won, and I think he was awarded not a farthing anymore, but a penny or a pound, the court, although it doesn't specifically say we're changing the law of libel, it speaks in charter-like language about the importance of the press and the important role the press has in commenting on political speech in much stronger terms than I have ever seen in the Canadian courts, and it is a direction which I hope we will soon see our courts follow. Thank you.
My topic today is the equality rights, and I'd like to start with a discussion of Section 15.1, the right to be free from discrimination, and then move on to Section 15.2, the affirmative action provision in the Charter. By way of introduction to my discussion of Section 15.1, however, I wanted to note that this is really not an easy area to present for at least 3 reasons. The first, and at a very theoretical and conceptual level, it has been suggested by Dean Hogg, who needs no introduction to this audience, that the law is in, quote, a shambles. And those are provocative words from someone who I generally regard as the master of understatement. The second reason why it's a difficult area to discuss is a very practical matter. It's difficult to discuss because another constitutional scholar, Chris Bredt, has suggested that the current Section 15.1 approach involves 16 steps before you can finally advise the court what you think the outcome is. Now, for someone like myself who's a fairly sedentary person, I'm completely breathless by the time I get through those 16 steps. And finally, it's not an easy area to discuss for semantic reasons. Perhaps incredibly, the appellant in this case is named Law. And so you end up discussing the law and law, which is quite a mouthful. So having provided these initial caveats, I'd like to now turn to the history and background leading to the law decision under Section 15.1. Section 15.1, as we all know, came into force in 1985, approximately 3 years after the rest of the Charter came into force. But the first major decision to reach the Supreme Court of Canada was the case of Andrews in the Law Society of British Columbia in 1989. Now, as most of you probably know this case, it was a case dealing with lawyers. And in particular, it was a case in which a non-citizen lawyer sought entry to the bar and was denied it based on legislative criteria. Now, although the court split on the result, the test they advocated, with the majority allowing Mr. Andrews' entry, but the test that they advocated was a unanimous test penned by Mr. Justice McIntyre. And it was a test that was very well received by the academic community and by practicing lawyers. It became like the Oakes test for Section 1. In other words, all you had to say is, I'm now moving on to my Section 15 analysis, we're going to apply Andrews. And everybody knew what you meant. It had a certain elegant simplicity. It only involved 2 steps. The first step was to see whether in either the purpose or effect the legislation created a distinction. It always did, otherwise we wouldn't be standing there. The second step was somewhat more difficult, but nevertheless, it was fairly straightforward. And that is, you had to determine whether or not there was discrimination. Now, if the distinction in the legislation was based on one of the grounds that are enumerated in Section 15.1, like race or national or ethnic origin, then you immediately pass through Section 15.1, and then the onus moved to the government to defend the legislation under Section 1 of the Charter. Similarly, if the legislation created a distinction based on an analogous ground, you again move through Section 15.1 to Section 1 of the Charter. Now, in terms of what constituted an analogous ground, the court said you had to look for features of the group that were similar to those that were enumerated in Section 15.1. And the way you did that was to see whether the group was characterized by stereotyping, prejudice, whether or not it was a, quote, discrete and insular minority, and whether or not the characteristics were relatively immutable, which means hard to change. Now, this case was applied in many cases in the early 1990s. And the only area in which there was some debate was on the breadth of the analogous ground categorization. For example, there remained an outstanding issue as to whether or not social assistance recipients constituted an analogous ground. And in Ontario at that time, the lower court had said that they didn't, and then the matter proceeded up to the Supreme Court of Canada where leave was denied. I should note, however, that just last week, the Supreme Court of Canada granted leave on that issue in a case called Gosselin coming out of Quebec. The real problems with Section 15, which led to Dean Hogg's comment, began in the early 1990s. At that time, with new members coming onto the bench, the court began to splinter. And in particular, there were three clearly discernible strands in the Section 15.1 jurisprudence. The first, articulated most elaborately by Madam Justice Leroux Dubé, was the broadest interpretation from the claimant's perspective of the equality right. And she basically said, where you can show that there's a violation of human dignity, you pass through Section 15.1. The second strand, that articulated by Justices Corey, Iacobucci, McLaughlin, and Sapinka, remained true to the Andrews test. And in particular, they were highly critical of the third strand, which is the strand I'll get to now. The third strand was what I'd like to call a gloss on the meaning of discrimination. And in particular, it was suggested that where the exclusion was relevant to the purposes or the function of the program, then there was no discrimination. And this approach was supported by Justices Laforêt, Gontier, Major, and the then Chief Justice Lemaire. And it became known as the relevance approach. Now, in a series of cases around 1995, in fact, 6 cases, which is a lot of cases, the court continuously exhibited these 3 different strands in their judgments. Now, sometimes they all came to the same conclusion, but it was certainly a hard slog getting there as you went through the various different judgments. So we see this splintering in Egan, Miron, Thibodeau, Benner, Eldridge, and Eaton. Now, you can imagine that in the academic literature and among lawyers practicing constitutional law, there became increasingly a cry for some unanimity in the court. And so the court responded in 1999 with a case which was unanimous. And a new test emerged, the law test. Now let me explain to you what the facts are of this case first. Ms. Law had been denied Canada Pension Plan survivor benefits, CPP survivor benefits, because she was under the age of 45. The way it works is that starting at the age of 45, you get gradually more and more benefits as you get older, survivor benefits, and she was under 45. The Supreme Court of Canada found that this type of program did not violate Section 15.1. It found that essentially the purpose was to provide older spouses who were not likely to be able to replace the income of their deceased spouse with state benefits. In other words, Ms. Law, because she was younger, did not fall within the purposes of the program. Now, I won't take you through all 16 steps in law, but what I'd like to do is take you through the test in order to highlight how the court achieved a consensus. And what I'd like to suggest to you is that they achieved a consensus, and yet no one gave up anything. Now, starting at the beginning, it looks very much like the Andrews test. All right, so you have to find a distinction, not difficult to do. You have to see if the distinction is based on an enumerated or an analogous ground. Then you move to discrimination. And this is where things start to diverge from the Andrews test. And specifically where you see those 3 strands which I just discussed in the definition of discrimination. But they're called now contextual factors. The first contextual factor, and in fact it's the overriding contextual factor, is that articulated by Madam Justice Leroux Dubé in the earlier decisions, a concern for human dignity. And as part of that concern, you look for stereotyping and prejudice, and an indication that the legislation treats the individual less kindly from a concern and respect perspective. Then the test moves to an analysis of whether or not there's a history of prejudice, whether the program helps a disadvantaged group, what are the nature of the interest, the scope. These were the traditional kinds of things that you looked at under analogous grounds in the Andrews test. And as a result, you now have on board not just Madam Justice LaRue Dubé, but also the 4 judges who supported the continuation of Andrews. So that just left what was then called the relevance test. How are they going to get these people on board? And the way they did that was to include within the contextual factor the following factor: to consider whether from the point of view of the purposes of the program, whether the excluded group fell within that purpose. And the language that they used is, were the merits, capacities, and circumstances of the excluded group sufficiently different that it was not discriminatory to find them excluded from the program. So having included what is essentially a variation on the relevance approach in the law test, they were able to get everybody to sign on. Now, 2 important questions remain to be asked about this test. First, how different is it than Andrews? And I would like to suggest that it'll be quite different. And the way to make that point is to look at the outcome in the law case itself. I'd like to suggest to you that if law had been subjected to the Andrews test, there would have been a violation of Section 15.1. And that's because they would have found the enumerated ground of age and then passed right through. Instead, in law, they found there was no discrimination under Section 15. So I think we can anticipate different kinds of results. The second question, which is far more vexing and difficult to answer, is, does law truly reconcile these 3 different strands? Or just does it merely incorporate irreconcilable differences and ultimately end up being highly subjective? Is there any way for, speaking as a government lawyer, using the law test for us to be able to give clear advice to legislators on whether any particular piece of legislation would be found to violate Section 15.1? And I don't know that answer to that question. It's still early in the days of the application of the law test. But it's something that, when we have a discussion at the end of our session, I invite your comments on. I'd now like to switch gears a little bit and turn to Section 15.2, the affirmative action provision. It has always surprised me how few cases there are dealing with Section 15.2 of the Charter. And so the one case I'd like to focus on is a case called Lovelace and Her Majesty the Queen and Right of Ontario and the Chiefs of Ontario. Now, like Section 15.1, this is not an easy case to talk about, but there are different reasons this time. First, and this is no small problem, the leading case, Lovelace, has not been decided. At the time, of course, when I agreed to talk about the decision, I had somewhat assumed I could have a case comment of the decision, but it's been pending in the Supreme Court of Canada now for just over 5 months. And so I'm sure next year, anything I say about Lovelace will have to be completely rewritten. But we hope that the decision is imminent. The second problem is that I acted as co-counsel on that case for the government, and I have completely lost the ability to be objective and neutral as a result, and therefore to provide a dispassionate account of it. In any event, the thesis I'd like to develop in the course of my discussion this morning is that what we will see in the discussion of Section 15.2 is a mirroring of the debate that I have just gone through in Section 15.1. But before I elaborate on that thesis, I thought I might just give you some of the background to the Lovelace case. The case involved gambling on a reserve. The casino in question, some of you may know about, is Casino Rama, just north of Toronto, on the Magickaning Reserve. Indian bands, as defined under the Indian Act, and the government of Ontario had negotiated over the course of 4 years for this casino. And it's similar to Windsor and Niagara in terms of its scope and the kinds of things you can do there, but it's different in one crucial respect, and that is, instead of the net proceeds going into the Consolidated Revenue Fund, it's to be distributed to all of the bands in Ontario. Now, two sort of interesting little tidbits about this project. First is that while owning a casino is not exactly the same as a license to print money, the benefits are fairly substantial. In fact, to continue with the gambling, some would say the bands have hit the jackpot. The second interesting tidbit about this case is that the government's lead negotiator was Bienvenu. And therefore, it was not surprising when the case did go up to the Supreme Court of Canada, by which time he was sitting on the bench, that he wasn't sitting. And as a result, because he wasn't sitting, another judge had to recuse herself or himself. And so the panel that actually heard Lovelace is somewhat smaller than the normal Supreme Court of Canada bench. Now, the challenge in this case is from the Métis and non-status Indians, who allege that their equality rights under Section 15.1 had been violated, and they would like access to part of what's called the First Nations Fund, which is essentially the net proceeds. These appellants are individuals and groups who either by choice or by statute or by history are no longer within the definition of status Indian and do not consider themselves to be members of bands or could not be members of bands in some instances. But they identify or they have Aboriginal ancestry, and they identify as either Métis or non-status Indians. So now, turning to the Section 15.2 analysis, the first question that one has to ask is, well, is this an affirmative action program? Now, there's no doubt that this has a corporate commercial flavor. And in fact, the representative for the Magickaning said, this isn't really about affirmative action. This is just a license, and it's a corporate commercial venture. But from the government's perspective, at the very least, it is regarded as an affirmative action program because, to use the words of Section 15.1, it is a program intended to ameliorate the conditions of a disadvantaged group. And it is different than Windsor and Niagara insofar as the money goes to the bands. The second question is whether the casino, as a 15.2 type of program, violates the equality rights under Section 15.1. And although we have no idea what the Supreme Court of Canada will ultimately decide, I thought I might put forward three possible ways in which they could approach the question. The first is that suggested by the appellants in the Supreme Court of Canada. And basically they suggest that 15.2 has absolutely no relevance where the challenge is from a disadvantaged group. Now, it'll be interesting to see how the court deals with that proposal, since there's nothing on the face of 15.2 that suggests that access to it is a function of who is the potential challenger. But it is also interesting in that these are the potential beneficiaries under a different program of a 15.2 of a very broad interpretation of 15.2. And so what their approach suggests to me is that there's a very deep distrust, even amongst disadvantaged groups that could benefit from 15.2 programs, of providing any deference to the government when they go about developing these programs. Because 15.2, if it was adopted in a way that was deferential to the government, would be more likely to insulate these programs from judicial review. So that is one proposed approach to Section 15.2. The second is that which was adopted by the Court of Appeal unanimously. Now, you'll have to in Lovelace, and you'll have to remember Lovelace at the Court of Appeal level was decided before the law case came down. So at that time, the Section 15 jurisprudence that they were facing was this very splintered approach. So there wasn't a lot of inspiration for them from the 15.1 jurisprudence at that time. And so they turned to the human rights case law. And in particular, at the time, the Supreme Court of Canada had recently decided a case called Gibbs. And in Gibbs, interestingly, the approach that had been adopted was exactly the same as the approach that was ultimately adopted by the Court of Appeal in Lovelace, and it bore tremendous similarities to what we've been calling the relevance approach under Section 15.1. In particular, what the Court of Appeal said is that where the challenger, the excluded group, does not fall within the purposes of the program, then the challenger will not be successful in demonstrating a violation of equality. If, however, the challenger does fall within the purposes of the program, then there will be discrimination made out. Now, in Gibbs, the facts were that there was a general disability program. However, those with mental disability were treated less favorably. And the court found, since the purposes was a general disability program, there was discrimination because mental disability should not be treated differently than physical disability. However, the program noted that if it had been just a program, an insurance program for hands for piano teachers, then it might not be challenged by other groups who might benefit from an insurance program. So the argument that was put forward in the Lovelace case was this was a program intended to benefit the bands because they had certain features which did not extend to the Métis and the non-status Indians. In particular, they had a long-standing interest in gaming. They had a reserve base upon which to put the casino. They clearly had an economic need, although that economic need also extended to the Métis and the non-status Indians. And they had certain statutory and other measures of accountability and identifiability flowing from their Indian Act status, which provided the reassurance needed when you're dealing with gaming, which has all sorts of possible money laundering and criminal kinds of possible outcomes. So the Court of Appeal upheld the Casino Rama program on the basis of what has been called the purposive approach, which, as I said earlier, is really very similar in many ways to the relevance approach under 15.1. Now, the final approach that could be adopted by the Supreme Court of Canada, and I think it could very likely be adopted, is simply to take the law test and tinker with it. They've just decided law. They finally got a consensus. They might, who knows, they might say, let's just build on law as it is to take into account the affirmative action context. And so some of the things they might do with the law test is, it seems to assume that if you're excluded from a program, that's probably demeaning of your human dignity in the law test itself. Well, they might say in the affirmative action program, exclusion doesn't really necessarily demean your dignity because, in fact, everybody's excluded except for the targeted group. So they might be able to tinker with the law approach, a modified law approach, but keep the same basic structure and use it for programs that they've found to be Section 15.2 types of programs. So those are some of the possible arguments and the background to the case. Now I'd like to get back to the question or the thesis that I posed at the front end, which is that the 15.2 debate will mirror the debate in 15.1. And in particular, what I suspect will happen is that just as in the jurisprudence pre-law, where there was a debate between those that wanted to focus on the purposes of the program as part of the 15.1 analysis and those that preferred to deal with that in Section 1, that same kind of debate is going to surface in the 15.2. Let me give you a concrete example. The court might say, as the Court of Appeal said, well, I'm going to focus on the purpose of the program, and the challengers don't really fall within the purposes of those programs, and so therefore, there's no violation of 15.1. Or they might say, we think that this purposes analysis of an affirmative action program should not be part of the Section 15.1 analysis, but should be better left for Section 1. And I think it'll be interesting to see how they ultimately resolve that very same kind of debate. Now, to conclude then, I'm leaving you lots of time, Alan. To conclude with my comments on Section 15.2, and to borrow again a phrase from the gambling context, the die has been cast and we're just waiting for the roulette wheel to stop. Whatever the result at the end of the day, Lovelace will likely provide answers and elaborations to the questions of what constitutes an affirmative action program, how these programs fit within our concept of equality, and as an added bonus, maybe the daily double, we might also find some clarification of the Section 15.1 law test as a necessary step before reaching the Section 15.2 analysis. Thank you very much.
Good morning. Well, I'm going to talk about something completely different. We have three very distinct topics, all very interesting. I hope mine will be too. It's about privacy rights in your dwelling home. It's about Section 8 of the Charter on reasonable search and seizure. And I have a paper included in the material called Privacy as an Endangered Species, the False Promise of the Charter. I have to issue a little bit of a caveat and apology in advance. I wrote the paper quickly before I left on holidays, and I was in a pretty surly, foul mood. And of course, when I came back, I felt relaxed, and I was kind of horrified when I read the paper because I thought that the impression I left was way too bleak. It made it sound perhaps like we live in a totalitarian regime where we're all going to go home tonight and see SWAT teams in our homes. I'm not suggesting that at all. So I do apologize for the tone, but I think my basic premise is still sound, which is that I don't believe that adherence to legal and constitutional requirements of a reasonable search has improved at all since 1982. And regrettably, you could probably make the argument that it's actually declined. And the problem is that the sanctity of the home now stands in a very precarious position, because as we dilute privacy rights in other contexts, it will ultimately rebound to the detriment of the dwelling home. So this idea that you could shut your door and be free from state intrusion may be a noble aspiration and not one that is completely founded as a result of the enactment of the Charter. What you do find in Section 8, and you find this in Section 2B2, it's a very similar methodology. You have this wonderful rhetoric about the sanctity of the home, the ultimate indispensability of reasonable and probable grounds. I mean, no question the literary skills of the court have improved dramatically since the enactment of the Charter. The problem is, when you really look at the jurisprudence, you see that there's a paucity of effective remedies, the main remedy being exclusion. And you have to understand, this is what it's all about. It's not about the rules regulating search, it's about remedy. Everything we know about the rules relating to search were developed at common law. There are some new developments relating to like infrared technologies and things like that, but for conventional intrusion, the common law set the standard. And the only difference with the Charter is that we now have a remedy, because pre-Charter, all you could do was bring certiorari to quash the warrant. Well, first of all, very few lawyers could pronounce it, so they didn't want to bring it. And secondly, the only remedy you could get was a quashing of the warrant and often not even a return of the goods. You couldn't get exclusion. So if you're really going to evaluate where we're at with the Charter, you have to look at how 24.2 has applied to Section 8. And my submission is, and it's really not a unique perspective, it's sprinkled through the literature, is it's been a dismal failure, the way we've gone about vindicating privacy rights. Now, The bottom line is we really don't know where we stand. It's been 18 years since the charter was enacted, and there are really no valid empirical studies to demonstrate the impact of the charter. If you look at my paper, and I'm not going to really talk much about my paper, just lead you to certain portions, at pages 9 to 11 I discuss the empirical studies that have been done in the States. And they have some pretty remarkable statistics about police law enforcement adherence to constitutional norms and the impact of exclusion on conviction rates. Well, after 18 years, I really think we should be doing that in Canada. As an academic, I have spoken with the Department of Justice as to whether they're interested, and it seems like willful blindness is the key word. No one really seems to want to know. But we do know this, and this is what's disturbing, very disturbing. Prior to the enactment of the Charter, the Law Reform Commission of Canada issued their report on police power search and seizure. And they did a fairly extensive study of search warrants and discovered that 58.9% of search warrants were invalidly issued. So over a majority of search warrants should not have been issued. Now, one would expect that when you study the impact of the Charter in 1999, year 2000, we would discover that the compliance rate must be much higher. Well, in fact, Mr. Justice Casey Hill, with a few other lawyers, looked at an informal survey of some 100 search warrants and recently found that 69% ought not to have been issued. So in fact, there's a greater rate of non-compliance post-charter than pre-charter. Something is dramatically wrong. In my paper, I briefly address the issue of whether or not this will rebound to the detriment of privacy within the dwelling house. And the position I take, and I'm not going to go through the whole argument, is that ultimately the very restrictive approach we've taken will mean that intrusions into dwelling homes will occur with greater frequency and without justification, because 69% of those warrants are invalid. Now, just basically the structure of the paper, when you read it, you'll notice this, and it was carefully designed to sort of have this impact. What I did was at page 13 to 22, I discussed the rhetoric, and I give extensive quotations from various cases like Silvera, Evans, Hunter, and Southam. And it's funny, you know, when you string together the rhetoric and read it all in one fell swoop, you get the impression that when you go home, shut your door, there's no way that you're going to be intruded upon except maybe by rodents or criminals without proper authorization, that you are safe and secure from the police conducting fishing expeditions in your home. That's definitely the impression you get, and you'd feel good to be living in this country when you read the quotations. But then what I do, at pages 22 to 44, I look at the actuality of how the rhetoric is played out. And what I discover is there's limits to this rhetoric, and there are three basic culprits. I just realized I better do this, or else we may be going right through lunch. Not because I have that much to say.
Be able to eat lunch.
Yeah, okay. Anyways, the three culprits as I see them, and what's happened is that.
My job will be to put the hook.
Yes, exactly, please. I would appreciate that. One is what I see as a new development where courts are creating new powers of intrusion. This is despite the very clear rhetoric where courts say we are not mini legislatures. We do not create reasonable powers of search. We simply limit what governments have done. Yet when you look at my paper, you're going to notice that there is a more indulgent attitude in the courts in recent years to retroactively, through something called the ancillary powers doctrine, to say, yes, even though there's no statutory power to do that, we say at common law you can do it because it's reasonably necessary. I don't think the court will ever create a power of intrusion directly into a home. I just don't see that happening. But that more tolerant, indulgent attitude is basically sending a message to the police that they can push the limits of the Constitution and get away with it. And the issue that we have to grapple with in this decade is whether or not there is a power of search incident to being detained, which doesn't exist by statute and is being created like wildfire in every appellate court. And the Supreme Court of Canada had an opportunity in 1999 to take leave in a case called Ferris in BC to address the issue, and they didn't, sending a signal, in my mind, that they don't care as much about courts creating powers. So that's the first problem, a more liberal attitude towards vindicating the powers of the police. The second and more troubling culprit is the way we look now at the validity of the warrant. When we had certiorari applications and you really couldn't get a remedy, boy, courts were technical. Oh, you didn't dot the I's, cross the T's, that warrant is invalid. Now suddenly that there is an effective remedy looming in the background, we again see a very indulgent attitude. Two things in particular to note. I talk about a case called Morris from the Nova Scotia Court of Appeal in 1998. I do a lot of work in the area of search and seizure, and I've never seen Crown attorneys cite a case with greater frequency than Morris, so you know something's going on there. And basically what has happened in Morris is two things. One, falsehoods in a search warrant information do not necessarily have to be excised from consideration by the reviewing judge, despite the fact the Supreme Court of Canada is very clear on that. So the police now can be a bit more inaccurate without having to worry about a reviewing judge excising it. More significantly, they've really watered down the reviewing process because they say when you have a voir dire at trial to review the search warrant, you can amplify the record, which we always knew you could, but the police can now amplify the record to explain why the warrant was invalid and then render it valid. So you can get an ex post facto explanation at trial for why they forgot to put certain things in or why they might have misled the court, and that will then be taken into account. So the entire process has become a bit of a sham, this ex parte process, because the police have a second kick at the can. If they don't do it properly in the ex parte, they can now do it properly with the reviewing court at trial. That's very dangerous. The second part about the warrants that's problematic is this. We rely extensively on Crime Stoppers in this country. Anonymous tips are very dangerous. And the Supreme Court of Canada has said that when the tip is anonymous, there's a heightened need for police independent corroboration of the tip. Well, when you look at the cases I cite, the recent cases, it's really quite sad what's happening. The police receive a tip that Alan Young has firearms in his home and he lives at a certain place. Well, all the police are doing is driving by the home, making sure I live there, checking on CPIC, and suddenly they say the tip's being corroborated and the courts are agreeing. And all they've done is corroborate innocent details that all my friends know about, my parents know about, my employers know about, and it really doesn't mean that this person has reliable knowledge of criminality. And these are intrusions into dwelling homes, and they're being premised upon these unknown tips that could be from vindictive neighbors, with the police doing absolutely nothing to corroborate it. That's been a big problem. When you combine it with the third culprit, which is the exclusionary rule, then you see what the problem really is. A watered-down warrant requirement and a watered-down remedy. The net result is, in my opinion, the police are getting the message. They can take shortcuts. Despite the rhetoric in Burlingham and Mr. Justice Doherty and Golub about not taking shortcuts, they are taking shortcuts because they know they're not going to be held accountable for it. Now, I don't want to go through my argument. It's there. You can either accept it or not accept it. I may have too idealized the notion of the process and holding the police and courts up to too high a standard. But as I said, it is a thesis that's being advanced by a number of commentators who really feel that Section 8 is becoming moribund. What I do want to talk about in the time I have are 2 points. I want to speculate on why this is happening, because I think it's important to understand why the courts don't seem too responsive to these claims. And then I do want to propose for people who do work in the area a way out of the black hole of Section 24(2), because there is a developing trend which I think can be exploited to sort of shift the focus back onto privacy. Now, the why. Well, at page 45 of my paper, I do cite Professor David Rudofsky, who was a critical legal scholar in the 1980s, who probably should use his words and not my own. Has this kind of quasi-paranoid, conspiratorial idea of why courts have great rhetoric, but not much in practice. He says the most significant social impact of the constitutional principles of due process is not their effect on crime, which is minimal or non-existent, or even the basic fairness they can and do provide in some circumstances. Rather, it is the appearance of fairness they lend to the criminal process, as well as their legitimation of a class and race-biased judicial process. No question, there is a legitimation going on when you enact constitutional entitlements and you think things are fine, you become complacent. I don't believe there's some great conspiracy among judges to maintain racial and ethnic biases within the system. They exist independently, unconsciously, perhaps consciously with some people, which is unfortunate, but that's not what this is about. This is not an attempt by the judiciary to take away our privacy rights. I used to adhere to that more critical school of thought, and then I just realized that there isn't some master plan. There just simply can't be, and judges don't get together once a year, at the Arctic Circle in a secret cave to discuss how they're going to screw us. So I'm comforted also to see that there is a social science study, which I cite at page 45, and I always welcome these types of studies, where 9 years of judicial decision-making at the Supreme Court under Section 8 was examined to determine what's motivating them. Now, I can't say much about the study because I don't understand the methodology at all. It was very complicated in my mind, but it's a methodology they've applied to the U.S. Supreme Court also. And the conclusion, and this is a bit comforting, is that our court is not driven by ideological considerations in the same way the U.S. Supreme Court is. And then they sort of meekly suggest that they're more driven by the facts of a case, and I'm not really sure what that means, because that can be intertwined with ideology too. But at least on the first social science examination, we don't have a court that has a crime control mentality and is going to work to subvert charter rights. That's not what's happening. Why the court is not giving remedies for breach of privacy is very simple, in my opinion. They don't understand this. They don't understand what it is to be intruded upon in a dwelling home. As most of us don't, because I'm going to take a guess that probably very few people in this room have ever had the police arrive with a search warrant. Anybody? And let me read you something. I had to clip this because this occurred on my birthday last year. This comes out of Vancouver, and I'm just going to read you the headline. This is a reality that is lost on the courts. And I'm not saying this happens every day, but believe me, a close approximation of this happens. December 1st, 1999, a young mother says, and I'm sorry, this is a little disgusting, says she and her 2-week-old baby were both splattered with the blood and guts of a dog shot with a submachine gun in an Abbotsford police raid that took place during a children's birthday party. Searches are like SWAT team raids, especially when you get into the drug area. And in fact, the Ontario Court of Appeal in 1989 in Gimson said search warrant execution in drug cases has to have an element of surprise and even some modicum of brutality. And this is what's happening. Don't think they show up, knock on the door, and say, "May we come in?" They knock on the door because they have to make an announcement. They wait a few seconds. If they don't get a response, if it's a drug raid, there will be a battering ram to your door. And in a case like this, they intrude upon a birthday party, and they basically traumatized the children. I have a case in particular where they raided a home. They always bring about 8 or 10 officers, and they come in with their guns drawn, and they put the owner of the home on the floor with a gun to his head, and the child is watching, a 4-year-old child. And this child now has developed a phobia for people dressed in uniforms and is going into extensive therapy. Oh my God. Okay, 5 minutes left. So,
We're generous.
I haven't even started, but anyways, that's fine. They don't understand what's going on with searches. What they do understand, and what my paper I think makes abundantly clear, is they understand right to counsel. It's enormously protective, the regime they set up. I'm quite proud of it, but I'm not sure it's really that important. So you get to call a lawyer. We all understand that because we're lawyers. But you ever thought about what a lawyer tells the client when they call? Ever thought what that person does at the 1-800 number where they call from the police station? Keep your mouth shut. Keep your mouth shut. There's not a great deal of skill that goes into that. Yet you're going to find an unbelievably expansive regime. Why I wrote this paper was because I read a case called RTA, which came out in February of this year. It's a decision of Mr. Justice Shaughnessy. And the issue was this. A diary was seized. It's a sexual assault case. A diary was seized from the accused. And it was excluded from evidence based on Section 7 because the judge said that introducing the private thoughts of this person would compel the person to take the stand to explain away his words. Now, I don't disagree with it. I think it's quite interesting. But we've never had this notion that the right against self-incrimination is violated by some tactical burden. And it dawned on me when I read it that if this was a Section 8 case where the warrant was invalid, the diary would have gone in because it's non-conscriptive evidence. And something troubled me about that. And then I started thinking about other countries and realized that in Germany, for example, diaries will never go in because they have a concept called legally unobtainable evidence, not illegally obtained evidence. We focus on the police. They focus on the privacy rights inherent in the materials, and diaries cannot be introduced. And it seemed to me that was a more appropriate way to deal with the situation in Shaughnessy instead of twisting the right against self-incrimination beyond recognition. Give you another example of where we just failed to recognize privacy. Wiretap. I probably only have 2 minutes left, but I make 2 more points. Wiretap. What happened was, in 1993, the government amended the criminal code to take away automatic exclusion for illegal wiretap. I thought that was a very bad development because I can't think of any intrusion into a dwelling home which is greater than wiretap, where they put room probes or monitor your telephone lines for a minimum 60 days. All your private conversations in your home are being picked up. Well, what has happened, now that they've amended the code and there's no exclusionary rule, you have to deal with it as a search and seizure issue, and you have to go to 24-2. Well, the Alberta Court of Appeal in 1998 in a case called Pope, based on Stillman, and all the lower courts are following it, have said wiretap is non-conscriptive evidence, therefore it doesn't affect the fair trial, therefore presumably it's going to be admitted. Now this is really strange if you think about it, because in Stillman, they gave great constitutional protection to a drop of blood being pricked from your finger and the mucus emanating from your nose when you blow your nose. That received greater constitutional protection than your private conversations for 6 months in your home. And that shows the judiciary is somehow missing the mark in this regard. I was going to say it's not a sinister thing. I think the problem is in search and seizure is the evidence is incontrovertible. It usually forms the basis of conviction. The court has shown itself incapable of divorcing the constitutional claim from the facts of the case. We're dealing here with patently guilty people, and that's the problem. See, with confessions, there's always this residual doubt as to whether or not the confession is real because we know people falsely confess. But drugs are drugs, weapons are weapons, and I just don't think the court can get its head around excluding that. Last point I'll make, because I know I'm out of time, I see you looking, is I wanted to tell you how to get... I told you, total state surveillance. How to get out of 24-2, the black hole? Well, there is a development which I think is worth following, and I outline it at pages 37 to 44. As I mentioned at the outset, all the terms and conditions of a reasonable search were developed at common law. There's very little new here. And what the courts have been saying, slowly but surely, is that police ignorance of well-recognized legal and constitutional rules is tantamount to bad faith. And I cite all the cases where they say that. And in fact, what's happening is police officers who don't know what their constitutional obligations are, who aren't being trained, courts are considering that to be a systemic failure that undercuts any claim of good faith. So when you approach now Section 8 and 24-2, you have to start cross-examining the officer on his or her knowledge of leading cases. I can tell you, the moment you do, the Crown will stand up and object that it's irrelevant. How can the officer's knowledge of the law be relevant? Well, it is, because under 24-2, you have to look at the state of mind of the officer. It's a no-brainer, so it goes in, and it's a lot of fun. It really is. I mean, cross-examining them on not just whether they know cases, more importantly, when the last time they had training. And what you're going to discover, for example, in the cases I cite, is evidence is being excluded because the police have not received proper training on the implications of a case called Grant in '93, which said sometimes you have to get a warrant for a moving vehicle. And police forces just maintain their policy of warrantless searches of vehicles, and the Manitoba Court of Appeal in Lamy said, can't. We have to exclude because the long-term consequences of letting the police ignore the law will be disastrous. So there is still some hope in developing that, but I do end my paper on a depressing note, as I said it is, because I tracked 3 leading Supreme Court cases which established fairly clear rules. Kokesh, no perimeter searches. Silvera, no premature entry before a warrant arrives. And Evans, no knock-on olfactory searches. They're all quite clear, and I tracked their legacy. And sadly, courts are still admitting evidence routinely in violation of those 3 cases, even though in Silvera, in particular, the Supreme Court said this may be one of the last times we'll admit evidence where the police prematurely enter a home. So something dramatically will have to happen, probably a revisiting of Section 24.2, so it can provide a much more meaningful vindication of privacy claims, because currently it's just not working. Thanks a lot.
Thank you, Alan and Laurie, for those provocative and entertaining talks. You know, our theory when we were developing this program was we couldn't talk about everything in the Charter, so we picked 3 topics: a fundamental freedom, equality rights, and of course, let's get Alan Young to come in and talk about legal rights, and he takes one and provokes and entertains us enormously. Hopefully that's given you some overview of substantive rights, and I think raised some questions about how far we've come, if we've come anywhere at all, in the almost 20 years that we've had a charter, assuming we can understand what the courts are saying. I think we can take a few minutes for questions, is that right? Since we've got a slightly longer lunch break now, so. Laurie has a question, go ahead. Turn the mic.
It's more of a comment.
Just a little response.
And it's just that the first session talked about Section 2B of the Charter, and the thesis that was put forward was there's too much respect for privacy in our libel laws. It's time we made things more public. Then we got to Alan's discussion of Section 7 and Section 8. And what was the thesis? There's not enough respect for privacy. We really should be keeping things more private. And so I think that what it highlighted for me was that, you know, balancing either the public's right to know or the interests of an accused in a fair trial with desires for maintaining privacy and reputation and security is just an incredibly difficult balancing exercise, and you're never going to please everybody, even some of the time.
If I may just briefly respond, I don't know much about the libel cases, but I assume they're less about privacy and more about reputation, but I really have to look at them to see. But I think it's important to realize that you've always got to have a contextual approach to your analysis, because Laurie's right. It's not that privacy is completely disregarded post-charter. In fact, when you look at the O'Connor cases dealing with production of sensitive and confidential records, suddenly we have consideration by courts of the privacy rights of complainants and victims of crime. I mean, that's a dramatic development and quite a powerful one. What I'm referring to is more about privacy in the context of investigative powers of the police. That's where I think we've sort of let the public down. But in other areas, I think the Charter has been useful in terms of protecting privacy. So you've got to look very carefully at the context in which you're talking.
Yes, Patrick.
Maybe I'll ask Alan a question, because I know virtually nothing about the area, so I was proposed by his comments to sort of offer 2 comments and maybe get him to react to it. First of all, in terms of what is going on here, isn't there a simpler explanation, which is simply that the court is sensitive to public opinion and to their understanding
To deal with your latter point first about there's still practical value because these cases create precedents and rules for the future. Yes, in fact, they do have value. I mean, someone has to wonder if there's no remedy, what's the point of the whole exercise? Well, at least the court has articulated some basic principles relating to Section 8. The problem is, and this is what I mentioned at the end of my presentation, when I track Kokesh, Silvera, and Evans, which set out fairly clear rules, I don't think they're being abided by. So again, it becomes somewhat academic. Even the precedential value of the cases are muted. I would have thought that after Kokesh came down, which was a prohibition on perimeter searches, you can't trespass on property, walk around the property, look in windows. I would have thought every case subsequent to Kokesh where the police would do that, it would be automatic exclusion because it's an affront to the system. It's like flouting the rules. And that's not what we're seeing. So that rule guiding quality of judgments may not be there. So that's the first thing. The second thing about courts being sensitive to public opinion, you may be right that there are simple explanations. I mean, we sometimes mystify the process way more than we should. But you got to remember, the weird thing is, in Collins, the leading exclusion case, the court was pretty clear to say that this is not about public opinion. And the whole idea of the charter is to protect minorities from the views of majority of the public opinion. So they shouldn't be doing it. But it's a human process, and you can't be faulted. And it does reflect my experience with lay people and what their views are on the charter. When I teach a class at U of T, an undergraduate class, and I don't do this with law students because they're too sophisticated. They're always thinking, like, what's the trick, right? But with undergraduate students, I ask, how many people in the class think the police should obtain a warrant before they enter a home? And you get pretty much 95% putting up their hands, which is consistent with what opinion polls show. You know, you get the 5 renegades who are, anti-authority and don't want any intrusions. Then what I do is I ask the question by setting up a horrible scenario. I always use Paul Bernardo and talk about they obtain an invalid warrant to go into the house to obtain those horrific videotapes, and there's no reasonable grounds, no particularity. I go on and say, how many people in the room will exclude? And I might get 1 or 2 hands. And so what's happening is people respect the articulation of the right and the principle, but they aren't willing to pay the cost. See, rights are a luxury. They really are a luxury, and they have a cost. And the cost is that we are going to wrongfully acquit some people. And I just don't think we've reached the stage where we accept that. We do in some cases, and don't get me wrong, it's not as if it never happens. But if you look carefully at the exclusion cases, you're going to find an interesting phenomena too. You find a lot of exclusion in cases where there's other evidence, so that the convictions can still be sustained. But you don't find a lot of exclusion of non-conscriptive evidence where that forms the essence of the case. So, yes, they're consistent with public opinion. The question is whether that's legitimate to be so.
Yeah.
I have a question for Laurie Sterling. I would agree with you that the law test is essentially a recipe for a judge to decide anything on any case, depending on which of the contextual factors they dial up or out.
Did I say that?
I thought I was attributing that to Professor Hall.
However, what I'm very curious about is how the Attorney General, whose office would go about determining whether an objective individual would feel that their dignity has been violated. That's a very nice phrase. I wonder how you find evaluating something like that when you're giving advice on a potential statute or challenge.
Right. The idea that dignity is in the eyes of the person who's alleging the violation. Well, I think that the Supreme Court of Canada has tried to respond to that by saying here are some benchmarks of what is included in the concept of dignity, and those are the contextual factors. But I think it's a sort of a classic example, and maybe it gets back to what Patrick was saying, of where you sort of have nice theoretical principles, and then you go to apply them to day-to-day practice, and it's very difficult to do so.
So I'm reminded of Potter Stewart, who said about obscenity, I know it when I see it. Yeah, question?
So, I'd like to comment on the wonderful speech about the Libel Commission. Is it possible that the Supreme Court was trying to elevate the protection of petition to quasi-decisional status, especially the fact that the Quebec, the Chamber of Rights in Quebec, which has constitutional guarantee protection of
Yeah, I think that's clearly what they are trying to do, is they're looking at reputation as an aspect of privacy or as an aspect of security of the person, and I think that's quite a legitimate exercise. And you can see it in other cases. There's a case from Quebec called Aubry about photographing somebody on the street, and that was an invasion of her privacy rights under the Quebec Charter of Rights. And although it's not a charter case, it does also reflect that interest in your own sense of privacy about yourself and your own sense of self-worth. My complaint, though, is that that's fine to do that, but it doesn't then trump Section 2B, in the same way that even fair trial rights don't trump 2B, and yet it seems to me, my reading of Scientology is that it does. Any more questions? Yes.
Yes, I have a question for Lori about section 15.2. I guess what troubles me about the Lovelace case is that there's a risk in it that there's going to be so many hurdles put in place for government that they're trying to do or construct an ameliorative program that it may, I think, and perhaps this is something that Ontario articulated, I can't recall, it may be that there's the ultimate message is that you're going to make the courts will make it so difficult for us to try to do something for disadvantaged groups, we're safer not to bother in the first place. Do you think that's a real risk, that sort of deterrence potential if the Supreme Court comes out with something kind of messy and hard to advise your client on in the Lovelace case?
I wish you'd said that to the court when you were up there. The Court of Appeal decided, one of the reasons it decided on the purpose-based approach in Lovelace was because it was very concerned. Affirmative action programs, there's no positive duty on government to develop those programs. But they are good programs, at least insofar as the Court of Appeal saw them as a means to achieve equality. So, given that the Court of Appeal wanted to encourage the government to come forward with projects perhaps like Casino-Rama, perhaps a program in which the government pays for visual aids for those that can't see, wheel-trans, those kinds of things. They adopted a test which was quite deferential. And the idea was that this would encourage the government to be more beneficent, not always banging on doors sometimes, with good programs. So I think that the Court of Appeal was concerned about that, Lucy. I will see whether the Supreme Court of Canada echoes that concern. I think, quite frankly, it is a real risk that if it becomes just too hard to develop an affirmative action program, if the advice is it can always be challenged by another disadvantaged group, that in fact it may dissuade the government from engaging in these kinds of activities. And that would be unfortunate.
Maybe we can take one more question at the back. Thanks.
Yes, this is again for Lori about Lovelace, speculation, of course. Do you think that there's a risk or a possibility, depending on how you're looking at it, that instead of even touching on 15.2, that the court will simply decide that it is not discriminatory under 15.1 on the third part of the test, in that based on the purpose, which is to assist bans, and I'm thinking in terms of the overture and Gibbs that you referred to, and also the recent case on temporary, I don't know the name, can't remember my name half the time. The recent case on temporary disability issues and relating to the CPP, where they said this isn't part of protecting people with temporary disabilities, is not part of the purpose of the program.
The question, just to rephrase it slightly, is does law, just as it currently states, does it encompass the affirmative action context already? In fact, it makes the point so clear that it's so malleable it can encompass anything. But I do think that the court is wedded to law. and that the point you raise is very good, in that they may just simply say the law test is a contextual test. We are going to simply apply it, same criteria, but using the contextual background of an affirmative action program. They have to say something about 15.2, because 15.2 is a signal to the courts that affirmative action programs should not be treated in Canada the way they have been treated in the States, and in particular in the case of Baki, which was a medical admissions case. So we know that in Canada, 15.2 has to have some impact. But the question, I guess, is whether the law test, as it now stands, is sufficiently malleable to provide that impact.
Okay, thank you very much. We'll resume at 10:45.